The benefits of digital markets are well known. However, the challenges presented by the growth and power of a number of very large digital firms are also now well recognised. These firms are able to take advantage of their powerful position and cause considerable harm to consumers and to businesses who use their services, as well as to their competitors, with the potential to slow down innovation and growth. Over recent years, the UK has played a leading role in understanding these markets, including through our market study into online platforms and digital advertising. Through this work, we've considered how best to address the challenges. And after a period of analysis of information from a vast range of sources and extensive engagement, we, along with the ICO, the UK's data regulator, and Ofcom, the UK's communications regulator, provided our advice to the UK government in December last year, recommending an ex-ante pro-competition regime for the most powerful digital firms found to have strategic market status. The regime would be overseen by a new Digital Markets Unit, or DMU. Under the proposed UK approach, the DMU would undertake an evidence-based assessment as to whether a firm has strategic market status. That is, whether the firm has substantial entrenched market power in a particular digital activity, and where the effects of that market power are particularly significant or widespread. This focus on specific activities is intended to ensure the regime is proportionate and targeted. We won't be the answer to every digital problem. The DMU will consult transparently on its decisions to designate firms as having SMS, and our expectation is that this would only apply to the most powerful digital firms. For designated firms, the regime will then have three elements. The first is the Code of Conduct. The code will set out the upfront rules of the game for the SMS firms in relation to their designated activities. It'll provide a clear set of principles governing how the firm should behave when dealing with users such as consumers and businesses. In particular, it aims to ensure users of SMS firms can trade on fair and reasonable terms, have open choices, and are able to make informed decisions. We anticipate the DMU will have an important role in translating the government's objectives for the regime into enforceable codes for each SMS firm, reflecting the particular characteristics of the markets in which the firm is active. The focus of the DMU will be in supporting SMS firms in complying with the code, but it will have tough enforcement powers available to enable it to deal swiftly and effectively with any breaches. The second element of the regime is the pro-competitive interventions. These remedies, such as data mobility or interoperability, will enable the DMU to tackle the root causes of SMS firms' entrenched market power, removing barriers to entry and making it easier for innovative competitors to enter the market. While the Code of Conduct is needed to ensure SMS firms don't abuse their powerful position in digital markets, it won't be sufficient to deliver competitive markets in the long term. Pro-competitive interventions will therefore be crucial for building dynamic, innovative and competitive digital markets in the long term. Finally, the third pillar of the regime is the SMS merger rules. These aim to ensure closer scrutiny of transactions involving SMS firms. Earlier this year, the UK government consulted on its policy proposals for a new pro-competition regime for digital markets. It also reaffirmed its commitment to legislate as soon as parliamentary time allows. Both of these, the substance and the commitment, are great news for our collective efforts to boost competition in digital markets, ensuring consumers and businesses get a good deal and providing a spur to innovation and growth in the UK economy. But we aren't there yet. There's still a way to go before a new regime is in force. In the meantime, while we wait for these reforms, the Digital Markets Unit has been established within the CMA in non-statutory form to focus on preparing for the new regime. The DMU should be a centre of expertise and knowledge in relation to competition in digital markets, and it should have access to the best possible information, expertise and skills. It should support competition and innovation, and should engage constructively with a diverse range of stakeholders. This is also something we're working hard on, particularly our engagement with users of digital firms and the startup community. We also want to be joined up with other regulators to ensure coherent regulation and outcomes. That's why we've established the Digital Regulation Cooperation Forum with the UK's ICO, Ofcom and the Financial Conduct Authority. Through this forum, we work to ensure that regulatory approaches are effectively coordinated. For example, earlier this year we published a joint statement with the ICO, which sets out our collective thoughts on the interaction between competition and privacy in more detail. We're also continuing to take action using our existing tools. The CMA has a market study into the mobile ecosystems market, a number of antitrust and consumer cases in digital markets, as well as merger cases. And lastly, we're working closely with our international counterparts through fora like the OECD and hope to increase that collaboration in future. These are global challenges and will need a global response. Today's hearing is an important way of sharing our approaches and learning from each other, and I look forward to continuing the discussions, hopefully in person in Paris next time.